Today's focus on Outer Temple Chambers Travel Talks is on motor liability. I'm joined again today by Ana Romero, a Spanish abogado, Thomas Ricard, a French advocate, and Gerben Janson, a Dutch advocate. Thanks to the combination of the Motor Assurance Directives, Section 3 of the Brussels Regulations and the recast regulations, and finally the European Courts of Justice's decision in the case of Odenbright, this has allowed injured parties to pursue direct right of actions against motor insurers, not just in the courts of the place where the harm occurred, or the place of the tortfeasor or the insurer, but in their home courts. This has allowed English tourists who get injured abroad as a result of a motor accident to pursue their claim in the courts of England, which necessarily means that the English courts need to apply the law of the place of the harm in most instances. As a great deal of British tourists either go cycling, driving, or just as tourists to Spain, France, and the Netherlands, we're in a perfect position to be able to discuss that with the three contributors today. The first thing I'd like to look at is the basis of legal liability in motor accidents, and whether or not there's a distinct regime for motor accidents, or whether or not it's covered by the general law of your country. Thomas, I think the most obvious distinction is in France. Is there a specific law in France for motor accidents?
Indeed. In 1985, a specific law was enacted. It's called the Loi Badinter, named after the minister who supported it. This is a law that, as its preamble states, aims at improving the situation of victims of traffic accidents and aims at speeding up compensation procedure. The condition of its application is the involvement of a terrestrial motor vehicle in the accident.
And Gerben, what's the position in the Netherlands?
Well, we make a distinction between a motor vehicle with regards to any other motor vehicle or any other party, and the motor vehicle with regards to an accident against pedestrians or cyclists. Because the first one is general tort law and fault-based liability, and the second one, a motor vehicle against vulnerable people, such as the pedestrians and the cyclists. That, to be honest, has been developed in the Netherlands based on case law and Article 185 of the Dutch Road Traffic Act, and that's more like I looked it up, a quasi-strict liability system with advantages for the vulnerable party, to be honest. We'll get to that later on, but that's a difference of the two. So it's very important to see whether, and it has to be on a public road, and a motor vehicle has to be involved. That's the same as in France.
And in Spain, Anna, how does the civil code deal with motor liability claims?
Well, actually, we also have a separate regime for accidents involving motor vehicles, which are guided by specific regulations which establish the quasi-strict liability system, which acknowledges the fact that the risk created by driving a motor vehicle stands at a different level than the usual negligence in other types of accidents. So where an accident occurs where a motor vehicle is involved, this will result in applying a quasi-strict liability regime that will hold the driver of the motor vehicle liable unless some contribution or exclusive fault in very restrictive cases is proven on the side of the other element involved in the accident. This in what concerns personal injury, but is the usual regime of tort negligence still applies for material damages. So the material damages suffered by the vehicles will need to be the recovery will need to be assessed on the basis of negligence, but the personal injury will be assessed on the basis of this quasi-strict regime.
So there are two different systems depending on what aspect that you're claiming for. Is that correct?
Exactly.
Okay. So in Spain, the injured party will always have to prove that the harm that they suffered harm or damage as a result of the act that they're complaining of. But the legal tests for whether or not that party has a liability will be different on what aspects the claim are involved. In one case, it's a case of quasi-strict liability. The other, they have to prove fault in the normal way. Is that right?
That's right, yeah.
And Gerben, in the Netherlands, therefore, you still have to prove that the incident caused you damage, do you? But then there are the different regimes with regards to establishing whether or not the party who's being blamed has a legal liability. Is that right?
With regard to the accident, the victim only has to state that the accident happened and that the motor vehicle was involved. Then the burden of proof jumps to the insurer. And when liability is set up, then the damages are normal law. There's no difference in that you're claiming where the liability is based upon. If, for example, I would claim clothing damages or anything, that would be the same kind of liability with regards to the motor vehicle. Yes.
Okay. And Thomas, it sounds as if under in French law, on the whole, there's effectively a strict liability regime when a vehicle's involved. Is that right?
Almost, but it's something that is often misinterpreted. The French Badinter law is not so much about liability. It is a law that is about compensation. It is at the very core of the reasoning behind how this law is applied. What you need is not to demonstrate a fault, but to demonstrate causation and the involvement of a terrestrial vehicle, the involvement of a car. That means two things. For non-driver, it's almost an absolute right to compensation, the exclusion of their compensation being limited to very hypothetical cases. And for driver victims, their right can be diminished, but the issue is not to demonstrate how they were involved. The issue is simply to demonstrate that they were involved.
In terms of causation, how is that established? Is it established on the basis of that they were more likely than not involved if there was a dispute, or that their injury was more than likely than not caused by the incident, or is there a more stringent burden there?
In France, you have a requirement of directness when it comes to causation. So you would look at the involvement of the vehicle. For complex accidents, it becomes slightly more complex, obviously. But you will look at the directness of the damage. You will look at the involvement of the vehicle, and then you would pull the string to see how far you can go. It is a rather straightforward, and it's something that is often quite different than in the UK, where we do not reason in France in terms of balance of probabilities. We would look at causation in terms of directness. However frustrating it is a French concept.
And Anna, in terms of causation, and I believe that we've had these conversations before in other cases with regards to cause, would a Spanish judge look at causation on the basis of it's established if it's more than 51% in terms of the scale of likelihood, or is there a different concept that applies in Spain? Well,
in Spain, there are different legal arguments that will play a relevant role when establishing causation, because the courts will also look at things like continuity in the medical treatment. They would look at things like how long after the accident occurred the victim attended his doctor or the ER or received some kind of medical attention. They would look at issues related to the damage caused to the vehicles to see or to assess whether such damage would correspond to injuries of a certain entity. So they will look at quite a number of evidence to establish causation. or to agree that there is a causation link between the injuries and the accident. This is specifically relevant also. There are some specific legal provisions which concern whiplash injuries, which are reflected in our new baremo and establish some criteria to establish causation for whiplash injuries, such as chronological criteria. There's the criteria of the entity of the material damage. There is certain elements which will need to be looked at or will be considered in order to establish the link between the injuries and the accident.
You'll have English lawyers constantly asking you about the balance of probabilities test, because that's the burden of proof that we apply in England, and it's going to be the burden of proof that a judge understands when looking at the evidence. But of course, the test of burden of proof comes under the applicable law. How do you, Anna, deal with English solicitors saying to you, well, does it meet the balance of probabilities test? Or does it really not matter, because effectively the judge in Spain is doing something similar to the judge in England?
I think effectively is similar, because the balance of probabilities at the end, they will look at, the context of the accident, which is what the Spanish judge will do. They will look at those elements that we were referring to before, the chronological, the material, which is at the end of the day the context of the accident. But I think they take it a little bit farther, because in Spain the medical treatment plays a very relevant role. So causation actually is also linked to receiving continuous active medical treatment, which is something that happens after the accident. And if there is not such continuous active medical treatment, there will be an issue about the causation between the link between the permanent symptoms or any sequela that the victim may suffer and the accident itself.
And Gerben, how do you deal with English solicitors asking you questions about the balance of probabilities?
Well, in the Netherlands, we have three kinds of causality. The first one is to establish liability. That's the conditio sine qua non. And once that has passed, we look for causation with regards to the medical causality and the legal causality. And the medical is, of course, when the doctors, especially in whiplash cases, say, well, perhaps we can't medically give a causality anymore to the accident. But we do have a legal causality system when we can still say that it is reasonable to establish the causality with regards to the accident. And as the same as in Spain, that depends on a number of circumstances. And of course, that's the same as all the circumstances of the case. And that again is just a bit the same as you were mentioning, which is the UK, the probabilities. It is close to each other, to be honest.
Moving on then to looking at the aspect of fault or negligence, and Gerben, staying with you, you talked about there being presumptions of liability in certain types of cases. What kind of cases do they apply to?
Well, if it's an accident with a motorized vehicle against a pedestrian and a cyclist, then there are two main important aspects with regards to the evidence and the liability-wise. Because the one is that the force majeure is very limited, and the other one is that the burden of proof is reversed, because the pedestrian only has to establish that the car was involved, and then the insurer of the car has to prove majeure to get under the liability, and the burden of proof is for the insurer, which is quite a high burden of proof here in the Netherlands. If they can't do that, then we have a system that is based on case law. If the victim is younger than 14 years, then it's 100% that they have to pay, unless it's really up to the victim that has contributed very, very much and acted in a very bad way to the accident, which has never been accepted in case law. to be honest. So when you say that the victim is under 14 years, normally in practice it means you have to pay everything. And if they are older than 14 years and older, then the basis is 50% if force majeure hasn't been established by the insurer. And that's a threshold. For example, if it's a 60-40 example, and then 40% own fault, you get the 60%. But if it's a 60% own fault, so you would normally get 40%, then you still get the 50%. So that's in order to establish protection for the pedestrians and the cyclists with regards to the vehicle. And if you have established the 100 or the 50, if you're still in that discussion, then we have two more steps. The second one is a causal contribution. So who has done the most to get to contribute to the car accident happening? If, for example, it could be 75, 25 own fault. And the last step is that you have a correction for reasonableness, and that is always in the advantage of the cyclist or the pedestrian, and you could still end up with 100%. But the burden of proof of how the accident happened is still on the insurer of the vehicle. So that's also an advantage for the pedestrian or the cyclists. So quite a good protection here in the Netherlands with regards to that. Not as good as in France, but we've come a long way.
But when the collision is between two motorized vehicles, there's no such presumption of fault. They have to fight it out between themselves.
Yeah, they have to fight it out between themselves, and it's a normal tort law, normal burden of proof. There is no, because the vulnerability is not there with regards to the cyclist or the pedestrian. Yes.
And Thomas, we'll discuss deductions for what in England we describe as being contributory negligence later on in this discussion. But effectively, the question in France, as you said, is not one of assumptions of fault. It's focused on an entitlement to compensation unless there's a reason for it to be reduced or eliminated entirely. Is that effectively the French approach?
Exactly. That is effectively the French approach. And when it comes to balance of probabilities, we really struggle to understand that. Sometimes it gets easier with a glass of wine, but we still we see the divide between French and England coming back when it comes to that reasoning. And you've explained it very clearly.
And just one other question based on the position in France. If, for example, there are two vehicles that collide, each separately insured, is there ever a debate between the motor insurers as to who would have a liability in that situation? Is there ever a debate there?
Yes, there could be a debate there, but that should not impact directly on the claimant's right to compensation, in particular the passengers. The passengers are entitled to compensation. The non-driver victims have an almost unfettered right to compensation. And so the discussion that may intervene between insurers should not impact on their right to damages.
One situation that we often find ourselves in England when we're looking at French motor cases is we're looking at, say, for example, a vehicle and there's a husband and wife. And let's say the wife is driving, the husband is the passenger. It's involved in a collision with another vehicle. And the husband, who's injured, is absolutely adamant that the fault was not on his wife, but was on the other driver. Would the husband be claiming from the insurer of his wife's vehicle or from the insurer of the other vehicle, or does it really not matter?
Well, first, it's very noble of him. Second, you would pick the insurer, his own or the one from the other party. But in any case, it might depend on the gravity of the offenses, and you would follow a very pragmatic approach depending on the type of insurance they have, their relationship with them, where and when the accident occurred, to get the most efficient process. As you may know, in France, legal costs are barely recoverable, which slightly changes the whole dynamic. and may also explain why we pushed for such indemnity-based regulation.
And just to close this section, in Britain, we have a highway code. It's a document where it sets out the basic rules of how you should drive, but there's no legal liabilities, certainly from a civil point of view, attached to it. Now, in package cases, there can be arguments with regards to the standard of driving abroad. Do you have similar highway codes in your countries, and are there any legal liabilities attached to it? Gerben.
Yeah, we have, well, to be honest, one of the three characters that we use to establish fault liability is the one that you don't act according to the law. And that one is also fulfilled by the Road Traffic Act. So if you don't act according to the Road Traffic Act, usually it means that you are very easily liable, to be honest. And to be honest, we on the right here, so that's one of the main differences with regards to the UK. But that's absolutely the case. If you act not according to the Road Traffic Act, then that's usually a very big argument to accept liability. With regards to the example that you just used with the wife being in the car, or the husband being in the car, that is exempted here in the Netherlands for the protection with regards to the 185 code. So that's normal fault liability, but we do have a system here in the Netherlands that the one being in the car, the passenger that has no fault that the accident happened, a code that says that if you don't have any fault with regards to causing the accident, then the insurer either wins, your own insurer or the other one. If there's discussion about the liability of the accident, then the one insurer that you ask first has to take on your case, pay all the liability and the damages, and then furthermore discuss it with the other insurer, that is to prevent the victim being sent from one insurer to the other.
So the obligation is upon the first insurer to sort it all out, and then for the two of them to have the debate about indemnities. And
absolutely. There's one big difference. It shouldn't be a car with a foreign license plate. So if a UK resident rents a car here in the Netherlands with a Dutch license plate, then it is applicable. If they bring their own car, then it's not.
I see. So best hire a vehicle when driving in the Netherlands.
With a Dutch license plate, yeah.
Absolutely. And Anna, are there any prescriptive rules of the road when it comes to Spain, either in law or in terms of guidance?
Yes, the position is very similar as to the one that Gerben was describing, and we've got our high codes, regulations. There's quite a number of norms that apply to driving a motor vehicle, and then obviously if you contravene one of these norms, this will result in liability for the one that hasn't complied with the appropriate rules. And coming back to the scenario that you were describing about claiming against your own insurer or the one as a passenger or the other vehicle's insurer, in Spain, and the norm is that the insurer of the vehicle responsible for the accident will in principle pay for all the damage caused by that vehicle, including the passengers to that vehicle and the passengers to the other side's vehicle and the driver of the other side's vehicle. But if there is a dispute on liability in the sense that it is likely that both vehicles contributed somehow to the accident, even if in different degrees, then the insurer of each vehicle will pay for its own passengers. So if liability is clearly on one of the vehicles, then that's the one that will pay. But otherwise, they will, each of the vehicles insurers will respond to the damage caused to the passengers in their vehicles.
Is that based on a specific rule, or is that a convention between the insurers?
It's a convention that has been developed by the case law.
I understand. Thank you very much.